I want to thank you for watching and tuning in to episode number 13 of At Your Service with Haber and Martinez. On the screen, you can see my companion, my cohort, my partner in crime, Edward Martinez, a.k.a. the man in black, well, the man in gray. And off to our left, to Ed's left, at least on my screen, we have Russ Walters, surety, bondsman, and human being extraordinaire, a very dear friend and colleague who I've had the privilege of knowing and working with for more than 30 years.
Thanks, Mike.
Our show today is called, the caption for it is Bail, Bond, and PreTrial Release. And Russ is a bail bondsman. You can probably see the striking similarity between he and Dog the Bounty Hunter. And actually, Russ, he's incognito today. He's wearing a bald wig. But we're going to talk to you a little bit about some interesting stuff, including bounty hunting, which is a fascinating subject. We have an awful lot to talk about on today's show. It'll not just be the law and procedure involving bond, but practical experiences that we've all had. Interestingly, Ed, apart from being a defense attorney now, as you all know, he was a prosecutor for a long time. And as a prosecutor, especially when he was in the narcotics specialty division, dealing with specialty bond issues in drug cases, particularly trafficking cases, which trigger all sorts of different rules and procedures, some of which we'll get into today, you will get a perspective from the lens of an assistant state attorney. You'll also, of course, get the benefit of Ed's defense attorney mind and my own. And then, of course, Russ will be able to give us a whole different take from the surety perspective. So, again, there's an awful lot to unwrap here. With no further ado, I want to welcome you, Russ. I want to thank you very much for taking time out of your busy day to be here with us. It's good to see you. It's always good to work with you.
Thanks.
And we're looking forward to spending the next 55 or so minutes with you.
Thanks very much. Glad to be here.
So,
Michael, I see you got a listener. I don't want to interrupt, but I see you got a listener from Belize, it looks like. You know Jose Witzel on the chat. Unless they're listening to Michael Miller. Well, we welcome them. We welcome them from all over the world.
Abs, I was just going to say, we maybe have to do some banking or diving there. I'm not sure which.
Diving.
But
hey, Mike,
good to know someone there.
You mind if I jump in and ask Ed a question just from the?
Go right ahead. That's what we're here for.
Thanks. It's a little off topic, but I thought I'd ask Ed, and I'm sure we're going to address it later in the conversation. But Ed, from a state attorney standpoint, when it comes to Nebbia, what's the general feel that state attorneys have with regards to satisfying a Nebbia? Is it as to premium only, or do they also look at it like we also want to know what the collateral is?
Let me tell you something. I can tell you when I was a state attorney, I know what we in the unit know what the law is. But it's very frustrating as a defense attorney when you get a young prosecutor or prosecutors that are the PIP prosecutors. They don't understand how Nebbias work. And for the audience, so they understand, there's a case that was a federal case. It was Nebbia versus U.S. or U.S. versus Nebbia. The guy's name was Nebbia. And he was a drug dealer. And they posted, back then in the heyday of the drugs, the judges would give $4 million bonds. And these drug dealers would just throw it down like they were throwing $20. And as Russ will tell you, the bail amount on a criminal case is to make sure that there's somebody who's going to come and get this person, or if they post it themselves, that they're not going to try and run because they'll lose all that money. So it's basically to make sure that person shows up. And so the prosecutors made a comment about how, well, Judge, if it's drug money and it's easy come, easy go for these guys, that really doesn't ensure anything. So we want to make sure that they don't use their drug money because they got an unlimited amount of money for their drug money. And we want to make sure that it's from a legitimate source. Now, here's what Nebbia does tell. And Russ, I think that's why you're asking. This is the law. Now, the reality of life is some judges and prosecutors don't understand this, but this is a law. If you hire a bondsman, what the judge really needs to ask and make sure that it's not money gotten from illegal funds is only the premium. That is the only thing the defendant is paying. So if it's a $100,000 bond, for sake of argument, and they're going to give Russ a $10,000 premium, Russ is responsible for the $100,000. Am I right, Russ? So far.
Correct.
So if anything, the judge wants to ask is, or the prosecutor is, Prove to me that this money comes from not illegal funds, the 10,000, and technically, I guess you would have to ask the bondsman, and you also are not going to be insuring the 100,000 with drug money, which if you're bonded, we know that's not going to happen. And let me give you a scenario that a lot of prosecutors and judges screw up all the time. Suppose, Russ, that somebody says they want to pay you the $10,000 premium with an American Express card.
Correct. That's an issue.
That money's golden.
Yeah.
Nebia satisfied.
Right.
Prosecutors will tell me, but I got to know how they're going to pay. What money are they going to pay back American Express? No, that's not the law. The law is the money that's posted as a bond, is that coming from drug money?
Correct. What's the source?
Right. If the defendant ends up defaulting on American Express and not paying back, courts can't get involved in that. That's a civil matter. And if the defendant ends up paying American Express with drug money, how are you going to prove it? He hasn't even paid it yet.
Yep.
You can't, but they do confuse it, Russ. And it's very frustrating as a prosecutor. As a criminal defense lawyer, when I come across a younger prosecutor, and sometimes even their chiefs and sometimes judges, which God bless them, a lot of times judges came from the civil world and they're thrown into the criminal and they're not up to speed. But that's the reality. That's how those mafias are supposed to work.
Right. So what's interesting about that is from a criminal defense lawyer standpoint and dealing with a lot of criminal defense lawyers, we're all faced with the same issue many times over. And that is, should we just try and satisfy the nebia as to premium only, or do we have to show the court that there is collateral and what the source of funds are for the collateral? So my question to you was from a state attorney standpoint, because you used to be a state attorney, especially in the drug narcotics unit, right?
Right.
The prosecutors in that unit, some are skilled veterans and some aren't, right? So the new guys don't know to ask about the collateral and they're just asked to premium only. And it's somebody like Mike and myself can go in and say the source of the money for the 10% bond premium is XYZ and satisfy the nebia. But the question is, what about the collateral? And so my question to you was,
the collateral needs to satisfy the nebia too. The collateral would have to satisfy the nebia as well.
Correct. I believe the same.
Right. Mike, so if you ask for a house and they bought the house cash, you would have to find out where they got the cash to buy that house.
And by the way, Ed, I don't know if you realize this, Mike's either sleeping or he's frozen. One of the two.
I think it's a little bit of both. If you know Mike as well as I do, you never know. It could be a little bit of both.
Yeah. So you know what's interesting? This is and actually, let's wait for Mike to come back up for a second.
You and I can
keep kind of readdress that. And by the way,
and let me tell you, if I may, sorry, Russ, I'm sorry to interrupt you, but briefly, this is why, as a bondsman, correct me if I'm wrong, sometimes you'd rather work with certain attorneys because they make your life easier. Because, for example, I can come in and I know exactly what case law and what to say to the prosecutor, even if they don't understand the law correctly. And I always try to do it nicely because I realize, especially as a former prosecutor and having done civil cases out here, on my own, when I first started doing civil cases, I was lost.
Right.
So I know this. I don't blame the judge. I don't blame the prosecutor. I don't fight with them. I try to give them the information, give them the case law so that they can learn and show them, listen, you don't need to approve a nebia if the premium can play with a credit card. You don't need to do this. You don't need to do that. If there's a collateral, and usually, let's be honest, on a $100,000, $200,000 bond, you're going to ask for collateral. But let's say somebody has a $10,000 bond. How reasonable is it for you to ask for collateral?
Yeah, of course.
It's not, right?
No. On a $10,000 bond, it's a roll of the dice whether we want to take the risk or not. Sometimes if there's a nebia, which is strange on a $10,000 bond, we just go in and satisfy the premium only. Right. And that's a whole interest.
Yeah. You do get some prosecutors who do it, let's say maybe not 10, but for 25.
Right.
And that's not going to fly. So tell us a little bit about, let's start from the very beginning. Okay. That was a little bit more of a special question.
Yeah.
Let's go back to the beginning. So let's explain. The very first thing is, Russ, explain to everybody what is, because we hear the term bond a lot, especially for us who work in the field. But technically, there really is a difference between the bail and the bond. And can you tell us what's the difference between a bail and a bond?
Yeah. So constitutionally, it's been set up where you have a right to bail. Bail being a certain amount set up by the court as to what would be sufficient to secure someone's appearance in court.
Right. And
So
that's what a bail is for. So you understand, that's all it is.
that's all it is.
The thing it's for is to make sure that the defendant will come to court.
Right.
That's it.
And Ed, if we break it down a little bit, if you take a minute from a republic standpoint and look at it as to, when they got together to develop and create laws, they got together and realized like certain things are unacceptable to society. And if you're arrested for those things, one of two things are going to happen. You're either going to remain in jail, or the only mechanism to allow you to be released while you're waiting to go to court to determine whether you're guilty or not is the pledge of something as a collateral instrument, as a tether to the courts to guarantee that you'll show up for court. So evidently at some point in time, they determined, okay, cash is in the amount of X amount of dollars predetermined by the court is to be posted on your behalf. So at that point, the option is, I got to believe, and I don't know this far back, but I have to believe at that point in time, you either had the cash to put up, because there wasn't any credit at that time. You either had the cash to put up or you remained in jail. Along the timeline of life, at some point, they came to realize not everybody has the cash. So they came up with a bail system where bonding agencies that are licensed by the state are welcome to come in and put up the cash for that person in exchange for two things: a premium of X amount of dollars, which has been standardly 10%, along with the ability for the bonding agency or agent to collateralize that as if it was a loan. And it's kind of a speedy, quick loan as opposed to going to a bank to borrow money. So,
well, and the other thing, correct me if I'm wrong, is the bondsman. There's two differences between the bondsman and the bank and going to a bank.
Yeah,
right?
Exactly.
The bondsman is bonded. One.
Yeah.
Because you have insurance. The other one is courts are not going that if you're going to go to a bank, you're going to have to get the full amount.
Yeah. Well, Ed, actually, it's another step reserved. It's not only are we bonded, but we're regulated. So we're part of we're regulated by the Department of Financial Services for the state of Florida, who oversees us. So it's a heavily regulated industry. Hey, Mike, it's a heavily
look who's back.
Yeah. So we started.
I promise you, Mike, I didn't say anything bad about you while you were.
No, I could hear you guys the whole time. I just wasn't in. I don't know what happened, but I want to cut.
Oh, you're breaking up again, dude. You got to get new internet service, Michael. Russ and I are going to keep talking. Just
All right. Just whenever you come in, Mike.
So you were finishing up. You're bonded, and then what else?
So we're heavily regulated. So each state is different. Some states they have property bondsmen, like in Georgia, where a bondsman actually puts up their property directly with the courts, and every state's different. But in the state of Florida and many of the other states, we're all regulated by the Department of Financial Services, which is the state of Florida. In this instance, they oversee us, they give us a license, and we have to follow certain rules and regulations. And it's a financial concept, so consequently, that's why we're regulated. So in this set of circumstances, we, like you were pointing out, versus a bank, it's a risk assessment for us, and it's the knowledge and wherewithal to find a way to quickly collateralize ourselves. So where you might want to go to the bank and borrow $100,000, it'll take you a month, 2 months, 3 months to get through the qualification process.
If you went to the bank, which is the critical point for the defendants, for the people watching, you would have to get. Let's say the bail amount is $100,000. You would have to get $100,000, put that into the registry with the court. Whereas the reason that the criminal court system actually prefers a bondsman. The benefit for you guys, for the defendant and the clients out there, is that you only have to pay typically 10%, right? 10, 15% of the bail.
Well, let's not be confused, because I want to make sure it's not confusing to the listener, right? So the way this works is somebody's in jail, the bond's $100,000. The options are go to a bank and borrow $100,000 unless they have $100,000. Either way, whether they have it or they borrow it, they can take the $100,000 directly to the jail, put it up in cash or cashier's check, and walk out of the jail. The theory is they get the money back when the case is closed.
Yeah,
although they don't actually necessarily get all of the money back.
Right.
They never get all the money back.
What most people are not aware of, and the jail doesn't tell them, and the courts don't tell them, is if you do that, they passed a law many years ago that says that the court can attach any cash bond. It's actually the way the county makes money, through their cash bond process.
Right.
So let's just simplify. Let's say the bond's $1,000, and somebody's brother comes down and puts up $1,000. Well, first of all, the brother isn't aware of this, but when he puts up the 1,000, if the brother owes the county any money for any reason, like back taxes, parking tickets, or they just take it right out of the cash bond. That's
Right.
number one. Number two is when the brother goes to court and the case is closed, if it's determined that he's guilty and they see they're holding 1,000, they could just make the fine 1,000 and take the cash bond. It happens all the time. So it's really
Court
not
costs, court
Even
costs, any of those types of things.
court
So
cost, exactly.
even
I
if the
wanted
case
to-
is dismissed, so everybody understands something. Even if the case is dismissed,
Court cost.
they will take court costs and other
Yeah.
associated costs out of that money.
Exactly.
So you never, ever, I've never had a client get all their money back. if they put
So
their
this is a pro tip, right? It's always, if you are worried about losing your dough or paying things that you don't want to pay, don't put up cash. Use a bondsman. But I want to go back to your Nebbia discussion for a minute. I had hoped that we would have had that discussion later in the show, but that's all right. I just want to say that it's interesting because we've done shows with different guests, and one of the people that we brought on was a private investigator. And Ed and I, talked with Carlos Fuentes. We talked with Carlos a great deal about the types of things that we do as a team in order to accomplish the objective for the client. Sometimes we have other experts. I had Dr. Brannon on a couple of weeks ago, and we talked about how I use him as a forensic psychologist. Well, in many ways, and especially when it comes to Nebbia, but in many ways, even not Nebbia, Russ, you're a very critical part of that team.
Right.
I have teasingly said to people over the years, and it's kind of a half truth, but I've said Russ Walters has probably forgotten more about Bond than I would have ever known in 10 lifetimes.
Thanks.
So when it comes to trying to structure, and we're going to talk about this a little bit, Russ is like the mighty Oz. We go to him and we use his 40 years of expertise to try and come up with creative ways. And so what do I mean by that? Let's kind of go back to the beginning, right? There's a constitutional authority for bond. You've got the 8th Amendment of the United States Constitution, and you've also got a constitutional provision in the Florida State Constitution. And you've got a series of Florida statutes and rules of criminal procedure that delineate the protocols and the things that need to be considered and the processes involving bond. But without getting too detailed and technical into it, it's a sliding scale. The presumption is everybody gets bond, unless you're being held for a non-bondable offense or you have some other hold or detainer lodged against you. You're entitled to bond, period.
It's the
Go ahead, I'm
simplest
sorry,
way,
you want to say something, Ed?
Yeah, just basically the simplest way, and I was going to get to that later. If the court determines that you are either a danger to the community or you are a flight risk that is beyond, a bondsman being able to ensure that you're not a flight risk, those are two of the reasons you won't get a bond. So you look at crimes that are non-bondable, right? Murders, first-degree felonies that are serious crimes. The court feels like a murderer is a danger to the community, and so initially there's a non-bondable. Now we can go.
I'm going to disagree. I'm going to disagree a little bit because we have in Dade County and most counties have what's called a standard bond schedule. And
Right.
The minute that any person gets booked into the jail, it is an absolute requirement that the arresting officer file with the jail a statement of probable cause and a list of charges. It could be 1, it could be 50, however many charges. And then the jail simply types in that information and boom, the magic bond number pops up. It may be no bond because of the nature of the charge or whatever the standard bond is. So let's just start with that premise, okay?
Well, that was my point I was trying to make.
Everybody has an innate right to bond in Florida unless you have a non-bondable offense. Now, everybody also, in terms of the defense or the prosecution or the court, has the right to revisit bond at any time. So you might be entitled to a standard bond as a presumption, but given your facts and circumstances, your bond may be in a position to be increased or decreased, right? At the request of whomever. And that's where I was going with Russ just now.
You left out what I was getting at the end. That's what I was trying to say. Basically, if it's a non-bondable offense, we start with the premise that you don't get a standard bond, and that's because of the nature of either flight risk or danger to the community. However, in Florida, even those people have a right to argue.
Right. Let's
Regardless
save
of what
that.
the claimant
Save
is.
that. Because again, we jumped
Okay.
into Nebbia at the start. I don't want to get into Arthur hearings
let's
now.
go.
We'll get there. I'm just
Right.
trying to, I want people to understand what bond is and
Right.
what the basic protocols are. So bond, again, everybody basically has a right to bond. That's the bottom line, unless you don't have a right to bond. So what I was getting at with the teamwork discussion was, right now, Russ and I are working on a case. We have a guy who's a narcotics case. It's a 2 kilo cocaine case. So it's a trafficking case, $250,000 standard bond with Nebbia, right?
Mm-hmm.
And unfortunately, the client does not have the means to post bond. He doesn't have property. He doesn't have assets. So,
Mike, let me jump in a second.
Please.
In this particular case, this is why I asked you this, Ed. I thought we'd jump off on the session with regards to the Nebbia, because the question was, in this particular case, the collateral is complicated. So Mike and I are faced with which direction.
Actually, it's non-existent.
No, it's complicated. There is existence, but it's complicated, right?
You're right. Okay,
right?
I agree.
So the question is, do we come to the court and not to hide from it, but the statute's clear. It's to premium only.
Right.
Right. So really, truthfully, as far as satisfying a Nebbia, all Mike really has to do is satisfy the source of funds for the premium.
Right.
And by the way, just so those people that are listening or in the future may listen, here's a set of circumstances that those people are probably not aware of, or the public's not aware of. In a bond situation or in a court situation, in many instances, there's many different hats to wear.
Yeah.
So the first hat to wear is we're trying to satisfy a Nebbia condition, which means we're trying to get the judge to approve the bond based on the source of funds for the bond premium only. That's the first hat. If you're successful in doing that, we can move forward and post the bond. Then you have you got a second hat. The second hat is what the family had by way of collateral. Then you got the third hat, which is the insurance company. And what we were talking about a little earlier, Ed, is that all bondsmen in the state of Florida work through insurance companies. So when we put up a bond, we're actually putting up a insurance company's money as a guarantee to the court. So the insurance company wants to know how they're secured. So in this present situation that Mike and I are discussing, was that in this case, there's collateral, but it's complicated, and it's probably best that we don't head in that direction.
Correct. And I misspoke earlier. I want to make sure it's clear. When you told me about the collateral, I assumed we were talking about the court requirements.
Yes.
Because sometimes the court can say, not only do I want this Nebbia amount, but I want a collateral.
And that's exactly where I was going to go with what you were saying before, which is you guys are all talking about prosecutors, but at the end of the day, sure, all of us would love for the prosecutor to just stipulate. But regardless, it's the judge who has to enter an order.
But
and
Mike,
so the prosecutor.
Let me finish what I was saying, because I want to make sure I'm crystal clear. I don't want anybody to think that I'm misleading them or I don't know what I'm doing here. If the court does not add a collateral requirement, but the bondsman wanted it, or your insurance company wanted it, the prosecution has nothing to do with that. Prosecution does not have to make sure that those funds are from illegal funds or the collateral was purchased with non-illegal funds. That has nothing to do with it. The only thing the prosecutor can get involved in, even the court, is in what is the law, which Nebbia, we know the law is the premium, or if the court adds other requirements, then yes, that needs to be satisfied, but only if the court adds.
So Ed, when we started off the session, the first question I asked you was a hypothetical. It was a question regarding what you feel, what your opinion is with regard, because you're a former prosecutor, and I'm asking you for a reason, because Mike and I have a decision to make going forward, and we're trying to get a feel for how prosecutors
collateral. I wouldn't even bother with the collateral unless the court or now if the prosecutor asks the court and the court says yes, but even if the prosecutor says, Judge, in this case, I want to make sure there's collateral. The judge says, well, I don't care, I don't want it. The court doesn't consider the collateral.
So
but there's another element to this. There's another element to this that's more on the Russ bond end. Okay. because bond is basically a three-party contract,
Right.
right? When bond is issued, when the judge says bond is X, whatever it is, the parties to that contract are the court, the accused, or the person who's posting the bond, and the bondsman. Those are the three people who are
Correct.
involved. The state is not a
Correct.
party to that contract.
Always
So,
an-
so when we start this process, now Russ has to do an analysis. Let's say that we have a $150,000 bond and we can satisfy Nebbia as to the $15,000 premium. But there's no collateral.
But
So
now I'm
Russ
faced
now
with
has
taking-
to decide, am I willing to write this bond? Do I want to take 15 grand to risk 150 if this guy doesn't show up?
Right. Correct.
Right. So that's the other hat to wear. So, and by the way, Mike, what's interesting is in the last 10 days, I've worked 2 different bonds out of Broward County, and look what they're doing. In both instances, one was a narcotics case and one was a vehicular homicide case. In both instances, the judge issued his order as to what the bond was, and in his order, he said 3 things: surrender the passport, that he wants to know that the bond is fully collateralized, meaning that they want to know whatever property is being used, 100% secures the bond, and proof of it, and proof of the recorded document. So Broward's taking a different position. What's
Well,
interesting?
Broward is taking the federal position, right?
Yeah. Well,
When you post a bond in federal court, that's the standard you're held to.
Mike, well, unless you're talking about corporate surety bond, remember?
Yeah, that's exactly what I'm talking about.
Yeah, well, in federal court, it's more likely you can pass a Nebbia as to premium only because they more recognize what the statute really deals with.
Correct.
In state court, and the reason I had asked Ed this question was I wanted to get a feel from him as a former prosecutor, especially in the drug unit, how the prosecutors felt with regards to Nebbia, whether they feel that they need to come in and bombard the defendant about what collateral you're putting up when Nebbia is to
They
premium
do.
only.
Yeah, they do, and they're wrong. And I'm telling you, they're wrong. As a former state
By the way,
they're
Ed,
wrong.
you brought up the issue regarding the credit cards. So I've been faced with that a dozen times in the last month, and I've always told my clients that yes, you can use a credit card, but we need to be prepared for an answer because if you get a veteran prosecutor, the first thing he's going to say is, "How do we know when your bill comes in for the credit card, you're not going to take money under the mattress and pay the credit card?"
And the case law is crystal clear. It doesn't matter. That's not your problem.
Because the source of funds actually comes from.
Because
but it's not your. It's
that
not.
moment is American Express.
Right.
It's not your problem until and unless the judge makes it your problem.
Right.
Because here's the other big thing about bond, which really is a universal truth about criminal court or any court for that matter. Right, wrong, or indifferent, lawful or completely unlawful. The judge is the king or queen of that little kingdom. And whatever frickin' ruling they make in that moment, no matter how retarded or sensible, you're stuck with until an appellate court reverses them.
And if you can't afford an appeal, you're stuck with it.
You're stuck with it, right?
And an appeal is expensive. And
Mike,
so,
hey, let me jump in a second and just tell you. So last week I had a situation, one of those 2 bonds in Broward, they wanted to use a credit card. I suggested to the client and the attorney, listen, we have to be prepared for the answer because if you get a veteran, they're going to ask you what's the source of money to pay the credit card bill when it comes in. And the attorney said, yeah, you're right. We don't know what the answer is to that. And then so I said,
minimum payments, minimum payments and lots of interest.
So there is a way to get around, like if you're trying to satisfy a Nebbia and you encounter that, and this is just in the spirit of being creative, you could probably propose to the court judge when the credit card bill comes in, we're going to put it on calendar, come before the court and disclose to you the formality of how that's going to be paid and get your approval for payment. And,
so let's just be clear with the audience that we've spent a lot of time talking about Nebbia, which is a very small percentage of the bond cases.
Yes.
So let's refocus and retask on the larger percentage and the concept that in Florida, the rules are written in such a way that the court is required to consider the least restrictive bond possible before it works its way up the ladder based on those 2 criterion that Ed mentioned. Right. The main purposes of bond, number 1, to ensure the defendant's appearance in court, and number 2, to protect the community. So with those 2 things in mind, the court is obligated by statute and procedural rule to go from the least restrictive and then work their way up. right? So the least restrictive is the thing that keeps Russ up at night, okay? And that is pretrial services or a release on your own recognizance, where the court says, look, you know what? You're not a flight risk. The nature of the charge is really not all that serious. You know, we're not worried about you fleeing or running. No problem. Go home, be good, come to court, right? So Russ gets no case. He has no bond to post, and he has no premium to make. And the problem is 20 years ago, that percentage of cases that were not given a cash bond has grown exponentially, right? And the use of these alternative methods of release, like pretrial services, have become much more prevalent.
So can I jump in?
Yeah.
Sure.
Question
So,
is,
as a quick example, and basically the public is not aware of this. So the pretrial services program that you're talking about is a county program that was established way back in the 70s when, and I take it you don't want to talk about the history of that, but the bottom line is that, like I just posted a bond 30 minutes ago for a young lady. It was a domestic violence related matter, and they rubber stamp every one of these. It's a misdemeanor battery charge. And there's hundreds a day, to the extent that it's grown so exponentially large, the domestic violence related incidences, that they've built an entire building around domestic violence. So what's happening is they rubber stamp almost every one of them, and they give them pretrial services with an alternate bond of $1,500. It happens all day, every day. So anybody,
and it's horrific because the people who get released out on pretrial services is a two-edged sword. On the one hand, they didn't have to post $1,500 bond and pay a $150 fee to the bondsman. But on the other hand, now they're obligated to call in, show up. They're being supervised. They've got the county up their ass. It's a whole nightmare.
extremely restricted.
As a defense attorney, having dealt with this many times, it's a case of buyer's remorse, right? They don't know what they're doing in that moment. They just spent the night in jail. It's probably been one of the worst experiences of their life for most people. And so they're not thinking straight. They don't have a legal background. They don't know the rules. They don't know the procedures. They're just going with the flow. And like you said, Russ, the judges are banging them out one at a time, one another, just shipping them out like cattle. But when ultimately they reach my office and we start talking about these things and they realize what their obligations are under pretrial services, now all of a sudden they want to post bond. But they can't post bond without being rebooked into the jail. And so it's kind of like a catch-22.
Actually, Mike, there is a way to do that, by the way, and I'll tell you in a minute. So what we've explained to them is that, and by the way, they're controlled by the county when they're in that program. So the reason they're given an alternate bond is, and most people are unaware of this, when they're released to the program, they have to go down once or twice a week in person, stand in line with 1,000 people, pee in a cup, do a drug test, and pay a monthly fee. When all they really had to do is pay $150 and get out, with somebody signing for them and making themselves responsible. So why would anybody want to do that for $150? So what happens is...
So that's, I want to cut in 1 second. That's pro tip number 2, okay? Yeah. If you ever find yourself at an initial appearance in front of a judge and they want to give you pretrial services, if you have the means to post bond, politely decline. Tell the judge, thank you, but no thank you. I'd like to post bond.
So there's a couple other parts to that, okay? So first of all, from the moment they enter the facility to be booked and processed, they're told immediately, don't bond out, you're going to get out for free. So they go through that whole initial booking and court process, the initial appearance, knowing that they're going to get out for free. And what they do without, and like you say, they're totally unaware of what's going on around them. They stick the papers in front of them to sign and they're released. So what's happening, and when they sign those, they don't know what they're signing. They're just told they're getting out for free. When really, they capture them. The second part to that is that the only way pretrial services gets their federal dollars is by the numbers of people being released to the program. So they're basically competing with us internally. It's the fox in the hen house. So they're just pushing people out the door. So in this case, I'll give you an example of what we've been doing. This girl calls me about her sister. She's calling and she's crying, and she's Russian, by the way. And they had an altercation.
What's her hurry?
Yeah. So exactly. She couldn't call me enough times today to get her sister out. And so bottom line is we had to wait for her to go to court because, as you know, with domestic violence, they can't bond out until they see a judge first because of the stay away order issue. And secondly, in this case, the judge did exactly that, pretrial services alternate bond. when I was explaining to the sister, you have two options, because I like to fully disclose to them. She can either be released for free to the program, but this is what that means. If she's released to the program, this is what she has to do. And before I could even get the words out, she said to me, I don't want her in any program, post the bond. And she did, you know.
Right.
So
Not that we want people to be doing, you know, nefarious things when they're out on bond, but, you know, look, if you're not subject to screening by pretrial services,
right.
isn't that better? I mean, don't you really, do you want to be drug tested? Do you want to, you know, be ordered in at a drop of a phone call to show up and report?
It's extremely restrictive, Michael. Every client I've ever had hates it. Every single one that I've ever had on pretrial services hates
it. The vast majority of cases, the bonds, you know, I would say it's like anything else, right? It's a pyramid. The largest number at the bottom of the pyramid are your least serious in terms of consequence and bond cases. $1,500 bond, $5,000 bond, $7,500 bond fine, $10,000 bond. You got to get up to the top of the pyramid to start hitting those $100, $250 million bonds. So, you know, for Russ, that's the golden goose, right? I mean, those are the ones you want to get. But the problem becomes collateral, because you're not going to put your name on a bond and risk $1 million of your own money so that some knucklehead can get out of jail, you know, on a nudge, nudge, wink, wink, I'll take care of you.
Right. By the way, to the second part of what we were discussing, if somebody's out on pretrial release and they come to you and they no longer want to be on pretrial release and they want to post a bond, here's the mechanism. Not too many people know this, but I orchestrated this when I was president of the association. I orchestrated this with the clerk's office. We could we could put it on the calendar on a motion to substitute surety. You have two orders. One order discharges the pretrial release. The other order says that in place of pretrial release, we're implementing this bond. And so they put it in the computer. We go upstairs, we post the bond, and the person's released right there in the courtroom.
The client
and that actually brings up another topic that's very similar, brings up another related topic. Mm-hmm. So a lot of times, the individual will get arrested for crime X, okay? Between the date of arrest and the date of arraignment, which is the day that the formal charges, if they're are going to be filed or announced by the state conducts an investigation. And, you know, I don't know what the numbers are. I would say probably the vast majority of state cases, the charge that gets filed mirrors the arrest charge. But in a good number of those cases, the state files different charges. Sometimes they do what's called a bind down, where they'll take a felony and instead review it and say, no, we don't have a felony, we have a misdemeanor. Sometimes they'll take a misdemeanor and bind it up and take it up to a felony. Other times they will add additional charges to the information, the charging document that were not contained in the A form. Now, you've already posted bond on the case, but now that there's a substantial change in circumstances, let's say that I get arrested for possession with intent to distribute, but the state winds up filing trafficking. So instead of looking at a second-degree felony, I'm now looking at a first-degree felony with a minimum mandatory. The game has changed, and therefore my bond is subject to being changed, again, at the request of the state attorney or at the request of the court. So in circumstances like that, I would call Russ and I would say, Russ, are you willing to stay on the bond, right? We need to get you in front of the judge. You might have to sign an affidavit or appear in person. And then you have to be questioned as the surety whether or not you're willing to stay on.
Yeah, number one, sometimes we have to provide an affidavit that says we're willing to stay on. Sometimes they increase the bond and we have to post a bond for the difference. And we do that in the clerk's office upstairs and bring it down and show the court, and the person can walk out. There's also kind of the new issue that's taken place in the last, let's call it 10 years, new being 10 years, where especially on statewide prosecutor cases, but more importantly, people don't know, a lot of attorneys don't know, in fact, the judges don't even know that a bond expires 36 months from the date it's posted.
You know, it's so funny. That's exactly what I was just going to bring up, because if you recall, about 4 or 5 years ago, you and I had a case where we had a prosecutor who will go unnamed.
Yep.
Let's just call her. Let's just call her. No, it was a female. So we're just going to call her she who must not be named. Okay. And so because she secured so many continuances on this case,
Is her initials GL?
I'm not talking about any of that. So she secured so many continuances based on her schedule and whatever, that ultimately at some point, 3.5 years down the road, she comes back and moves to rebook my client because his bond is no longer valid. Now that was $180,000 bond.
That's
the
right.
client had paid you $180. He had paid you an $18,000
Yeah.
premium plus
Yeah.
collateralized the bond,
Yeah.
right?
You remember
And I
that?
remember, we went through the property, we did the liens, we did the whole kit and caboodle because it was a very serious case and big money.
It was actually not a serious case. They were making it a very serious case to the extent that they had to post a $180,000 bond
with the
on
charges.
a $10,000 bond.
But then he got double raped when that motion was filed, and he had to post another $180,000 bond and pay you a second premium.
Yeah, and Mike was the king from that day forward. So in the meantime,
but do you remember when we were in court, that prosecutor was arguing? I mean, you would think that this was like somebody treading water in the ocean and trying not to drown, right?
It was ugly.
That prosecutor argued to the judge that he needed to be taken into custody then and there in the courtroom and booked.
She wanted blood.
And we spent the entire afternoon with our client sitting handcuffed to a chair in the courtroom.
Yeah, that was crazy.
While we went upstairs and you were able to repost all the bonds.
Yeah, I do remember that. And
could you imagine what a nightmare?
No, it's terrible. As a matter of fact, it's unfortunate because what's happening. So the judiciary is not aware of what to do. So when they encounter that issue, they don't know what to do. They tell the guy, go sit in the box. They don't have a policy in place. So I went to the chief judge at the time, and Stan, by the way, I went to Stan, and I suggested to him, I said, there's no policy in place like Pinellas County at the time, because it was a rather new issue. Pinellas put something in place, a policy that says that 30 days before the expiration of the bond, everybody's brought before the court to announce, hey, your bond's about to expire. You need to be here before the deadline, the drop dead date.
Right. It's called notice and due process.
Right, exactly. And shows the new bonds in place, and we're good. And at that point in time, the defense attorney can make argument, judge, he's been on bond 3 years, he's never missed a court date in his life, and the bond's fully secured.
ROR.
And we're asking you to ROR, which just makes sense, or reduce the bond to something more reasonable.
Token.
So whatever the outcome of that is, a bond is put in place. We come back into court, show a bond in place, and everybody's good. Dade County has no policy in place. The judges are unaware of the issue. They get blindsided. They don't know what to do. So it's just a matter of.
I got blindsided. I had never heard. Yeah, and it goes to show that even a skilled lawyer, much less a civilian, there are little technicalities and nuances out there that can bite you in the ass without anybody ever having thought about it.
And by the way, that's looked upon as a little nuance, but it's actually big in his case because it was $18,000.
Right.
I mean, fortunately for that client, the money wasn't the issue. He would have paid $50,000 to not be booked back into the jail. Yeah. But for the average person, so interestingly, we're still actually technically. Speedy trials are still told, right? For COVID. They've been told since March of 2020. Mm-hmm. As of now, and the order may change, I don't know, but as of now, if you were in a case that existed prior to that date, so in other words, if you were arrested prior to March of 2020,
right,
you are, as of today, although again, this could change before then, but you cannot file a speedy demand until October of 2021.
Wow.
And if you were arrested after March of 2020, you cannot file a written demand for speedy trial until January of 2022. Wow. Again, we don't know what's up with COVID, that those timeframes could be dragged on.
Right.
I would expect that the tolling of the speedy trial period for COVID would also toll the ticking of a posted bond. But who knows? Maybe it will, maybe it won't.
Nope. I can tell you by statute, it dictates 36 months from the date the bond was posted. So, and by the way,
but there's also statutes that say you have a right to file a written demand for speedy trial. So what I'm saying is there's a Supreme Court hold on those time requirements. I don't know whether or not that also affects that 3-year bond situation. Right. But these are the types of things that we have to think about. And one of the reasons that I use one of the reasons that you are my go-to guy is I know that when I have a problem, you're there to fix it.
Yeah.
I mean, like when we had this issue with the 36-month ticking and the prosecutor didn't give us notice, there was no written motion. She just got up one morning in court and said it. And, everybody's looking around, turning our heads going, are you kidding me right now?
Right.
But I knew all I needed to do was get Russ Walters on the phone and over to the courthouse and we'd get it fixed. And damned if you didn't.
Thanks, Mike. Thanks for having faith in me like that. I appreciate it.
Well, listen, you've earned it, Russ.
So I'm curious, just briefly in 30 seconds or less, what ended up happening?
Well,
nothing.
Two things.
He spent a couple hours in the courtroom. The bond was reposted, and he walked right out the front door.
And he was released. Yeah.
You had to pay the bond over.
Yeah, no, we had to repost the bond. He had to post a new. There was no Nebbia condition in it, but it had to be. Look, it's very difficult dealing. You know what it's like. It's a cacophony of players, right? It's like an orchestra. You got to deal with the clerk in the courtroom. You got to deal with the clerk at the bond window. You got to deal with the judge. You got to deal with the prosecutor. You got to deal with corrections. There's so many different players involved, and they're not always on the same page.
And by the way, the think ahead mode is really important at that point. You got to think ahead. What's coming at you that's going to deter? Because you're on a time frame where by 4 o'clock they're out. You know what I mean? Then you're on that deadline.
Which reminds me,
one other factor briefly. Correct me if I'm wrong. What you guys think? One of the problems we have, especially in situations like this, is that in certain counties, this county being one, people are doing it the same exact way for so many years that even if they're wrong, it almost becomes the norm, and it's so difficult to explain to them, you're wrong. That's not the law. They really think you're the one that's crazy and you have three heads, and it's hard to change that atmosphere.
Yeah, they don't change.
Well, noting the thing that we've been discussing on time, we're running short on time, and there are some other things I want to talk about.
Can we take 1 second? I want to throw something at you just for you to think about later, okay? So what you were just talking about whether COVID affects the trigger mechanism on the 36 months, right?
Mm-hmm.
So that's interesting because from that standpoint, there's this issue, and the question is whether or not the bond expires in 36 months because of COVID, and because of COVID, maybe, and the stay of the ability to request a speedy trial, whether that affects getting a speedy trial or not. And because of that, it might cause a differential in the 36-month statute, right? Okay, but then there's the flip side, which there's always a flip side, right, Mike? Right, Ed? There's always a flip side. So here's
at least one.
Okay, so let's say, here's the flip side. Ready? So let's say that for some crazy reason, the COVID thing affects that, and a judge, not an appellate court making the decision, but a judge says, you know what, because of COVID, we're going to extend it 36 months, which by statute they can't do, right? Because the statute says 36 months, right? Okay, so a judge orders, you know what, we're going to extend that another 6 months because of COVID and the ability to file for a speedy trial, right? Okay, so the 6 month comes, it's 5 months and 29 days into the 6 months, the guy's up for trial. He's nowhere to be found. He's gone. They forfeit the bond. Guess what? Bruce Reich comes in, or another attorney comes in on behalf of surety and makes the argument, hey, the bond expired in 36 months. And now the whole issue comes up. So just to show you,
well, this is
people that are listening,
that's litigation.
Multifaceted issues.
That's the nature of litigation. I want to ask you a couple of
briefly, Michael, I just got to say this briefly. This is a prime example of why you can't get a law degree by Googling.
Yeah.
See how complicated the simple matter is?
Yeah. Nobody would know that.
You don't know more than your lawyer just because you can Google. Go ahead, Mike.
So I want to talk about a couple other things real quick. I want to talk about, we talked a little bit about factors that the court considers in determining bond, right? They consider your ties to the community. They consider whether or not you're a flight risk. Are you a U.S. citizen? Have you ever escaped from prison? Have you ever run from the cops? Do you have fleeing and eluding charges? They consider the length of time that you've been in the community. Do you have kids in school? Do you own property? All of these things go to ties to the community. The more of them you have, the better, right? The less of them you have, the worse. And then the second part is dangerousness. Some crimes are inherently dangerous, right? Let's say that I get charged with attempted murder because I shoot my gun into a crowd. That's an inherently dangerous offense. Let's say I get arrested for jaywalking. It's, maybe dangerous to me, but, it's not what we would traditionally consider a dangerousness offense, or DUI, although that is certainly dangerous. But a simple DUI is not considered a crime of danger. So the court's got to consider all these factors when it comes up with whatever it's going to do with bond. Although we know, the three of us, as a practical matter, 99 out of 100 times it's just going to be the standard bond, right? If you want to change the bond or the state wants to change the bond, someone's going to have to schedule a hearing. But most times it's going to be just the standard bond, and that's the end of it. But in tandem with those considerations that the court must make, now you have the flip side of what is it the judge can do, right? We have a statute that lists standard conditions of everybody's bond, right? There are some things that it doesn't matter what you're out on bond for, and it doesn't matter how much your bond is. Those are required mandatory conditions. But
Right.
there's also a thing called special conditions of bond. And sometimes judges will, based either on their own sua sponte initiative or at the request of one side or the other, create a special condition of bond. So we have to cope with those also. And those are things that lawyers and bondsmen work together with to try and figure out how to make a presentation to the court so that we can get the best deal for our client with the least amount of conditions or restrictions.
True. Correct.
Yes?
Yeah,
Yes,
of course.
absolutely.
Again, this is why it's even something that you would think as simple as there's a bond and there's a standard bond. Shouldn't that be simple? Whatever the standard bond is, everybody. No, it becomes complicated sometimes, depending on the case, depending on the prosecutor, depending on the judge. All these things factor into it. And this is
So-
why it's a very complicated matter.
What we see most often, I would think, is either you have somebody who just doesn't show up to court for whatever reason. It could be a legitimate reason. Maybe they're in the hospital or they were in a car accident, or maybe they didn't get notice. Who knows? And their bond is revoked or forfeited or estreated, right? Or they commit a new crime offense. Let's say they get arrested for something else. There's any of a number of things that could happen for somebody's bond to get forfeit or revoked or restricted. What does that mean, Russ? What happens?
Mike, I just want to zero in on your question. What happens with regards to?
The bond being estreated.
Forfeiture, estriture, or revocation of bond.
Okay, so you mean how does that function? You're saying?
How does it play out? What's it mean for the client, for the defendant, or for whoever posted the bond? Let's say Ed gets arrested for lurking with intent to gawk, and I post Ed's bond, and Ed fails to appear, and
Right.
now the bond is forfeit. How's that play out?
So you're the responsible party because you're the one at your request.
Because I'm the idiot who bonded him out.
Yeah, you're the one that.
Yeah, I wouldn't do that. I'm not too smart.
So first of all, you're the one that supposedly put up collateral, and if you didn't put up collateral, the bond was posted based on your signature, and your signature, the documents you signed, and they're all pretty much the same. They all speak to the same issue. It's a hold harmless. You're basically saying, if you put up the bond for my friend for lurking and gawking, I guarantee you won't be at loss. And if you are, turn to me, I'll make you whole. That's the bottom line. That's what you're signing. It's a hold harmless, a promissory note. So if Ed doesn't go to court and the court issues a warrant and they forfeit the bond, what that means is the court is making a demand for payment. They're looking to me to pay the bond. And they're basically going to forfeit the money that I put up with the court, and I've got a 60-day window from the date he failed to appear to solve that problem. On the 60th day, if a judge signs an order by the 60th day saying you don't have to pay the bond, which is called a vacate of the forfeiture, an order vacating forfeiture, if an order is signed, it prevents me from having to post the bond. If it's not signed, that bond has to be paid on the 60th day. If I pay it timely on the 60th day, and let's just use an example, the bond's $1,000, he doesn't go to court, they forfeit the bond. On the 60th day, if I don't have an order signed by a judge vacating the forfeiture, I have to pay it timely. If I pay it timely, I have a 2-year right of remission by statute. What that means is, in a 2-year period, if I find Ed lurking and gawking somewhere else, and I bring him in and take it before the court, and I go before the court and ask the judge, I found Ed lurking and gawking.
Here's the body. So that leads directly into my next question, and I joked about it up front, and I know, look, you were once like myself, a young man. You probably had a lot more piss and vinegar in you at that time, like I did. But I want to talk a little bit about bounty hunting, okay? And I was joking about Dog the Bounty Hunter, but there is an actual component of the surety industry, of the bail bond industry, that involves, what we call bounty hunting, or typically people refer to as bounty hunting. So I don't know that you have ever done that. I don't know that you haven't done it. I know that you had a partner for a period of time who lived for that. Can you tell us a little bit about that? What the reality is? You know, if I post bond and I skip, or I, you know, intentionally flee or whatever, and I become a fugitive, what do I have to worry about looking over my shoulder? What is the extent of your authority?
So first of all, I spent the first half of my life as a kid kicking in doors, grabbing people that skipped, going with my dad, locating people. Life is totally different now, and there's such more of a liability issue that I've turned it over to people that specialize in doing that. I actually like the hunt of locating the person and then turning to a skip tracer who's licensed to do that. By the way, to be a skip tracer, you have to have a bail bond license now. So basically, once you're a licensed bail bond agent, you can go.
You are a bounty hunter.
Yeah, or you can't skip trace unless you have a license for bail bond.
Does your license extend outside of the state? Let's say that I'm out on bond and I flee and I'm in Texas or Louisiana or Oklahoma.
That's such a gray area. Like every state has different circumstances. Like some states, if you go, like Oregon, this is really strange. I had an opportunity recently to post a $2 million bond. All the players in the bond were incredible. The woman, it's a whole long story and I won't bore you with it, but the long story short of it is Oregon is a no bail state. They don't have bail in the state of Oregon. So bail bondsmen cannot go into the state of Oregon to retrieve somebody. In the meantime, the judge in this case, which was a Key West case on a real serious charge, it was a murder case, the judge allowed the defendant, once he posted bond, to live
to go to Oregon.
To go to Oregon, to live in a home that his fiance, who met him in jail, who was very wealthy, who owned several homes. She had a home in Oregon. She was going to allow him to reside in Oregon in her home. We chose not.
Do me a favor and find out if she has a sister.
Well, I think she's in Washington State.
Oh, even better.
So the long story short
cut you off, but I didn't want to cut you off when you said in Oregon something weird happened. I was going to tell you, period. That's all we need to know.
Let me hit a couple other quick points before we run out of time. Okay. I want to talk about traveling when you're out on bond. Okay. There's obviously three different scenarios. One, let's call it in-state travel. Let's say that you're out on bond here in Miami-Dade County for whatever, and you want to go to Disney World for the weekend with your family. Situation number two, same thing. You're out on bond here in Miami-Dade County, and you want to go to Las Vegas for the weekend for a bachelor party. And then example number three, you want to go out of the country, either on a cruise or what have you, but you want to do international travel. Let's hit all three in order.
Okay, so first of all, if you're out on bond and you or the indemnitor calls me and says, listen, I want to take you, the defendant, I want to take my wife and kids to Orlando for the weekend. I don't want to get in the way of that. You're going to Orlando for the weekend. But the reality of that is if you go to Orlando for the weekend, you get drunk and crazy, the cops come, you're incarcerated for any reason. It's a whole cluster solving that problem. And all of a sudden, first of all, it's expensive to correct and solve the problem. And it's cumbersome and it's time consuming, blah, blah, blah. So that's the first issue. But the answer to your question is based on risk as a bondsman, we're going to look at the risk of the likelihood of you taking your wife and kids and going to Orlando and something happening. I'm most likely not going to have an objection, but I'm going to make sure that I have an indemnitor that knows, first of all, I need the indemnitor's approval, because without that, the indemnitor can say, I didn't say you could go to Orlando, right? So I have to include the indemnitor, and I have to make sure that the indemnitor, if there's a problem and the person gets arrested in Orlando, the indemnitor has the money and the wherewithal to to solve the problem. That's the first issue. If you come to me and say, listen, I want to go to Oregon, or I want to go to Colorado for a week or something for an event, I'm going to ask you to cash out the bond and put up whatever the bond amount is and cash in our trust account. Most people want to know as soon as they return that the money's returned to them immediately. That's most likely not going to happen. Most likely we're going to hold on to it till the end of the case and return it when the case is closed, because now we're collateralized and the person likes to travel. But in some instances, we will return it. And the last question is, out of the country, absolutely has to be cashed out, especially in this day and age with what's going on worldwide. There's no telling.
So from the defense perspective, what I do is, and I tell all my clients, assume that you are not going anywhere without a court order.
I wish everybody.
So it's real simple. Call your lawyer. Pro tip number 3, call your lawyer, have your lawyer file a motion to travel. If the judge says it's okay, it's okay. But you still need to check with your surety. And so when I do a motion, the first thing I'm going to do is I'm going to call Russ and I'm going to say, Russ, Ed Martinez wants to go to Disney for the weekend. Do you have any objection? And if you don't, I'm going to make that representation in my motion to the court. I'm going to say, Judge, I spoke to the bondsman. If you need the bondsman, I'll bring him in, but I'm representing to you that that's the case. With international travel, always I tell my clients, do not go anywhere without a court order, because you're going to wind up with a problem at the border when they run you and see you're out on bond. And even though you may be right, you might wind up in a holding cell, and you're definitely going to wind up spending several hours detained and questioned for no good reason.
That's pro tip number 3A. You should get it, because trust me, they're going to hold you. They got to find out why you were out of the country when you have an open case.
Now, that's not going to happen on domestic travel, okay? Right. But it will happen on international travel.
And Mike, Ed, by the way, there's no statute that speaks to that. There's no statute that says you're breaking the law by going outside the jurisdiction of the court. It's just a judicial thing where some judges don't agree with you leaving the jurisdiction, and if they find out you did,
but some judges will order it too, so it can
Mike,
be a specific
that
order.
Same client that we talked about earlier on the $180,000 bond was not allowed to go one block into Broward County to see his kids.
Well, like we said,
and by the way, that same prosecutor on that case, I had filed a motion. He has a house in the Keys, so he wanted to be able to go on weekends and, just decompress and go fishing and whatever. And she filed a strenuous objection to it, and we litigated that. And she argued that he was going to get on a boat and leave the country because he had access to the Keys. And I'm looking at the judge going, Judge, what's to stop him from doing that right here in Miami? Why does he need to go to the Keys to get on a boat and leave, go to the Bahamas?
In Wyoming, you can do it. But guys, we are 1 minute and 30 seconds over. So let's wrap this up, Mike, in a minute.
Okay. I just want to say very quickly, Russ, your number one, thank you. As always, your experience, your expertise, your personality, none of them are rivaled by anybody in your industry.
Thank you.
You are the man. You are the Obi-Wan Kenobi. You are the Yoda. You are, the be-all and end-all in this industry. You've been a very good friend to me. You've been an excellent advocate and ally, and I appreciate you very much, and I'm really glad you were here. I hope you'll come back, because there's so much that we didn't even get to talk about. I mean, we didn't get to talk about ionic bonds. We didn't get to talk about forensic bonds. We didn't get to talk about high yield bonds. I mean, look at all these things.
You know what else we didn't get to talk about? We didn't get to talk about how many times Russ has bonded you out. But
that's a privilege. That's a privileged matter.
Thanks,
all right, guys. Thank you, and we apologize for running a few minutes over. But Ed, always good to see you and work with you. Russ, thank you so much again. Really, this is great. And we hope to see you all next week on episode 14. I don't know what we're going to talk about, but whatever it is, it will be scintillating.
Absolutely. Bye, everybody.
Take care.